Good day and evening, everyone. I'm Mark Bloom, Chair of the International Insolvency Institute, and I'd like to welcome all of you to the second of our quarterly member meetings designed to update and discuss developments of interest in the cross-border insolvency world. For many years now, III has been privileged to hold official observer status with the United Nations Commission on International Trade Law, appearing and participating at semi-annual meetings each year in New York and Vienna for Working Group V that focuses on dispute settlement and oversees arbitration and conciliation efforts, and Working Group V that debates and considers issues in relation to international and cross-border insolvency law. In particular, Working Group V has produced several core documents in its 30-year history, including the model law on cross-border insolvency that has been adopted in more than 60 countries and is at the core of a great many of our members' professional lives and careers. Last week, I had the privilege to join our five-member delegation to the 67th session of Working Group V, followed by a two-day colloquium on the guide to enactment of that model law in Vienna. I think it's fair to say that we found ourselves in some pretty illustrious company at the meetings, including as many as 20 or more III members attending as part of other member state or observer delegations and contributing meaningfully to the proceedings. Our meeting today is devoted entirely to a discussion of that Working Group V session and the colloquium, and I'm pleased to turn it over to the chair of our delegation, Adam Swick, who will introduce the other members of the delegation and present our program. Adam, good morning.
Yeah, thanks, Mark. Hello, everybody. Good to see you. We did just get back from UNCITRAL's Working Group V, the 67th session in Vienna. In fact, I landed on Sunday evening, so we are just back. Our formal delegation does have 5 seats. I attended as chair. We also had Evan Zucker, Olya Antel, Jose Carlos, who is on today and is going to talk a little bit, and Mark Bloom was able to join us as well, as he said. And also, as Mark said, look, we have 5 seats for our delegation, but if you look across the room at the United Nations, you have III members scattered across the entire floor for many different delegations. Stefan's on, he was there. Judge Cropper, Arit, like many III members were there and are contributing to the work that's being done. And what's really encouraging about it is that, we're discussing hot topics and we're directly contributing to international insolvency on a macro level. It's really quite encouraging. I wanted to kind of just talk informally about what we do, how it works, and the topics that are being discussed right now. I think it's all very interesting, and I think it's good for everyone to know. It's 2 weeks of a year. 1 week is in New York and 1 week is in Vienna, and it's 5 days formally. On the Sunday before, so it means Monday through Friday. The Sunday before is always an informal meeting where the delegates can get together and start talking about, the real hot button issues where it's hard to break ground formally on the floor, so we can kind of get together. And this year was at the Sigmund Freud University Law School. We got together and had some encouraging talks. And then oftentimes it's 5 days of formal deliberations at the United Nations. Like in New York, for example, we had the asset tracing, and we also had the choice of law in cross-border insolvencies. So we did 5 days, and we finished the asset tracing toolkit. That was finished, so now we still have choice of law, but then it's trying to figure out what to talk about next. So as opposed to doing 5 full days in Vienna, we did 3 days of choice of law, then 2 days of a colloquium, which was a good change of pace. And the colloquium really is 2 days of panels. And I think it hasn't been formally decided, but I do think the next topic will be amending the guide to the model law of cross-border insolvencies. And so we had 2 days of panels talking about where the guide is now, challenges with the guide, and things that could be fixed. And Jose is going to talk about it in more detail, but I really liked it because I look at the guide as in, what can it be done to fix the law that's out there right now? For example, things that I wish were changed with the U.S. interpretation of the model law. But we got to hear from people from Malaysia and different countries as to how, when they're trying to adopt the model law, the challenges that they have and what they look to the guide. And so, how can a developing country who wants to adopt the model law use the guide to make it work for them and get it passed through their governments. So that's kind of like the format. Um, the like I said, the asset tracing toolkit was done. That's been over a few sessions, and it was relatively non-controversial because it's not a model law. Countries can look to it, or if you're trying to figure out how to do asset tracing, it's a good guide. The choice of law issues for cross-border insolvencies, I'm going to open the floor so somebody can add an interpretation to this or their own perspective to this, but it's a really hard slog. I mean, we did get some progress to kind of the non-controversial areas of the choice of law, but there remains a pretty good deadlock. And as to the choice of law with secured transactions, set off, and fraudulent transfers, the EU kind of block of entities want to follow EU law, which is you apply not only the law where the collateral is located to the attachment and perfection of a security interest, but also the insolvency law. So, for example, if you have a bankruptcy or an insolvency in the United States as the foreign main proceeding, if your collateral is located in Germany, and Germany does not have a stay for a secured creditor, then in the U.S., that particular collateral should not have a stay applied to it, and the secured creditor should be free to go and take care to go and get its collateral. And so discussions as to how best to handle this have been ongoing. But it has been a pretty good slog, I would say, overall. So I do think we're in for a few more sessions with the choice of law provisions, which I think we'll do one more colloquium in New York, but I then expect we'll do 5 days choice of law if it's still going on, and then with amending the guide. So that is kind of the overall process and where we are with it. I would also say in Vienna, let me go back to III has been a very big supporter of UNCITRAL, and it is, I think, done really well for the organization. In New York, we did kind of a cocktail hour and a panel, and we flew people in from the Netherlands, and it's online, and I think it was a really good publicity for the organization and our working with Working Group V. And in Vienna, we had a dinner, which we had, I think, about 65 people attend, all delegates and guests, and I think that was very well received. And the dinner is almost primarily paid for by the people who attend. So, for example, III is not coming out of pocket for a lot of it. It's people just pay for their meal and they go to it. And, it's still getting a lot of connection. The secretariat and the chair were there. And I think very well received. And the organizations, III and Working Group V, are working hand in hand. I think it's a really good relationship. But I do want to highlight, and Jose is on, and he can talk about this in more detail, with the colloquium. So like I said before, we had a lot of III members who were delegates, but the colloquium was there were not necessarily everyone who's a delegate would speak, but we had a lot of panelists from III on these panels for the colloquium, and Jose is going to kind of walk through that, who was there and what the colloquium did.
Thank you very much, Adam. Indeed, as Adam was explaining, in the last 2 days, we had a colloquium talking about the guide to enactment, because it's true that it needs to be updated, or it was said so by Australia in the last session. So this colloquium was created to see which parts could actually use some updating. 14 members, if we counted well, were panelists in the 6 panels. So there were basically 6 panels. In the first one, there was Scott Atkins. It was on recent initiatives to enact the model law. The second one, which was actually the one I was in, and I was a former Nexian, now a member. There was also Harold Fu, also Nexian member, and Edith Meborach. We talked on the scope of the application and the definition of foreign proceedings. Panel 3, it was the one with more III representation. There was Stefan Madaus, who's actually with us now, Kat Borg, also former Nexian, now a member, Rodrigo Rodriguez, and John Poto, who actually was a delegate with another delegation. This panel was on the different type of proceedings, so basically main, non-main, and speaking of COMI and establishment. Judges DeVos and Peck were on panel 4. I think Her Honor DeVos is here. On relief and coordination across concurrent proceedings, there were actually some cases cited which are being worked on in the moment. Intersemen, for example, was a case that was mentioned many times. Dr. Yanis Sara was on panel 5 on the public policy exception and adequate protection of creditors. It was also said that this concept needs to actually be coordinated, let's say, between all the UNCITRAL texts. So it's not only a thing of this guide to enactment, but of a concept within UNCITRAL itself. And then panel 6 had Shuai Guo, who is next gen, Midori Yamaguchi, who is also next gen, and Rosa Rojas, who was an next gen. I think she's a member already, if I'm correct, on cross-cutting issues. So it was let's say, discussed in depth a lot of the broad ideas behind the model law. Here it was, for example, speaking about the concept of modified universalism, but we did get to, what a foreign proceeding actually is, what kind of proceedings we do have now, for example, in 2024, that didn't really exist in 2014, what happens with all the stakeholders, because it's true that the guide to enactment, for example, mentions certain stakeholders when referring to collective proceedings, but we do have a lot of proceedings now all around the world which have the involvement of shareholders, even third parties to contracts in sales of pre-packs. So there are a lot of, let's say, more modern uses of the insolvency law that maybe are not really related or shown in the guide to enactment. Of course, COMI and establishment were central themes explored. And well, it was talked about secondary proceedings, protocols, and the relief obtained in cases. And it was also explained that some of the cases already ruled on should be reflected on the guide to enactment. And as I said, it was spoken that we would need to clarify the concept of the public policy exception and adequate protection. And that's basically it. There will be a report, so there will be a written report for consideration in the next session. So part of the work that will be done will be to review the report on the colloquium on the guide to enactment. But as I said, maybe each panel had 4 panelists. So if it was 6, it's 24. The fact that 14 of those speakers were III members, I think it's a success for our organization.
Yeah, I think that's right. The III membership was, it definitely permeates all through these Working Group 5 meetings. Thanks, Jose. I appreciate it. I forgot to mention, too, we do have, as our committee, for anyone who would like to join, we have monthly meetings, and where we talk about the issues that are to come up at the next session. I see Andre Borain is on. He has provided a lot of research that's been very helpful as to, certainly to this choice of law with secure transactions, going back over the EU countries and other jurisdictions as to how they've treated this historically, and it's been very helpful. So I would like, if anybody else who's online, the III who is a delegate and would like to kind of, if you want to provide your perspective as to what happened and the progress of the Working Group 5, I'd love to hear from you. Stefan, you in particular, being from the EU, after I kind of called out the EU as to how things are going.
Yeah, I saw Judge Grapper shaking his hand and now raising his hand. So ahead.
It looks like Alan Gropper's trying to speak. I think he's gone mute.
Judge, please speak.
And I'm not usually a optimist, but Adam, I'm a little more optimistic than you are. You spoke of deadlock. We started out with a deadlock with the EU, but I think we've made an enormous amount of progress. Certainly from the beginning, we all agreed that the basic rule is that the lex fore concursus, a Latin term that sadly we are committed to, the lex fore concursus governs most matters relating to an insolvency proceeding, but there were, as you mentioned, Adam, a number of exceptions, some of which come from the EU reg, the choice of law provisions in the EU insolvency regulation, and most of which are very dear to at least a few of the hearts and minds of the EU participants. And they try to get a uniform and unified position. In any event, we are, I think, only down to 2 or 3 items that are controversial, and I think we're very close. I may be optimistic. I'd certainly like to hear from Stefan, because I think you're close to the EU group as to whether or not we're as close as I hope we are. One, as you mentioned, set off. I think we're almost there. The most important, perhaps, arguably, is the rights of secured creditors. And there, I think we have language that it looks like the EU can live with and that we can live with. And I'll come back to that proposition in a moment. Litigation and arbitration. I think we made a step back towards the very end, but I think we're close. And that's a very important provision, I believe, mostly in terms of the effect of the stay. You mentioned also avoidance proceedings. And there too, I think we are very close. I think we would all agree that the law, other than the law of the forum, the lex fori concursus, should apply in some circumstances when the parties to the avoidance case never anticipated that that law could possibly apply. And I don't think that provision is that different from our own Maxwell case going back more than 20 years. It's not a cross-border case. It is a cross-border case. It's not a model law case. It was decided before the model law was adopted in the U.S. and it's not based on model law principles. But I think that those provisions are pretty close. Now, the details are, of course, critical, as you mentioned, and but I think we've come a long ways. I have to tell you and Don particularly that the cross contract netting provisions, the EU woke up to the existence of the second sentence in that provision. Stefan is smiling. Perhaps it was you, Stefan, who woke them up. And the Italian delegate did ask, and of course, when one member of the EU makes a proposal, we may have 23 others say, yes, we agree. And of course, the chair says, oh, well, the numbers seem to be very much in favor of that proposal. So we are met with a sometimes block voting, because I don't think most members of the group necessarily understand what it's all about. But the Italian delegate did say at the end that he did not want to go beyond international norms. I don't think I'm misquoting him. In terms of a cross-claims netting provision that we were concerned about effects on the market, not on individual transactions. There was reference made to the UNIDROIT principles, UNIDROIT being an international group of lawyers who have very carefully looked at this issue. I'm not sure those provisions would fit in, but it's something we have to look at. So I think that we have a lot of work to do before the next meeting, which is in New York in April. And I'm not sure we could get there in April, Adam. I don't know what you think. I think you don't think we can. But maybe a year from now, there'll just be some minor cleanup. Let me just finish. I'm sorry to speak so long. by saying that we really do want input from the bar. At least I think that's very important for the bar to look at the current provisions. Don Bernstein and his colleagues have been very helpful to us as our experts on the provisions relating to the choice of law in market transactions and the like. And I think we're almost there, except with regard to the new provision, which is a cross-claim netting or cross provision netting, which is very broad, but perhaps no broader than the provisions we already live with in the United States.
No, that's a good. Stefan, did you want to provide any color?
Yeah, that would be great.
There's, yes, it was a very accurate report already. So there's very little to add, maybe just a little perspective. I think we've come a long way. And I think what gave the impression of going back a step sometimes was that we were now presented with draft model law provisions, which kind of were very helpful in illustrating what we're actually talking about, but also provoked some members or some delegates to basically rethink what they had previously agreed to, because it was clearer visible in this way than it was before, when it was all more or less broadly termed in a legislative guide. So I think it is very useful. I think we're down to a handful of issues that need final consent in one way or another. I think a closer timeline helps. So if we understand that we have maybe 1 or 2 meetings left to conclude deliberations, this might be helpful to find a compromise. I think the EU actually moved quite a bit, and Alan is right on that. And I think to keep ask us to move even further is all fair, especially since the EU often appears to be a bloc, which it isn't. So if you talk with the delegates from the EU, they tell you that this is hardly ever the case. But we find ourselves in a situation where we are ready to compromise, although it moves away from what we have as European law. And I think all of us understand what it means to compromise to an international text that provides provisions that are not reflected in the law as you know it so far. So I think it is not a small thing to ask, even if it only forms part of a legislative guide that is not directly changing your local laws. But I think we're far ahead already. So I think on the rights and rem issue, I think we're now down to a stay provision. The debate circles around whether the stay provision needs more guidance as to the length and lifting of the stay. So this is, details, relevant details, but I think that can be resolved. Then it's the scope question: should it be rights and rem? Should it be everything, every type of collateral, including intangibles? These are relevant issues, but I think this is a technical thing that can be eventually resolved, even if it is resolved in reducing the scope. The same on arbitration and procedural and other court proceedings. We're again talking about a stay under the Lex Fori Concursus that is mandatory. So again, the question is whether the length is correct or not. So I think we're close to something there. Financial contracts is always more complex. It always feels like every time we agree on something, in the next meeting, someone disagrees heavily and with substance. So I think more guidance is sometimes better there. Maybe we need someone in the room that appeases those who kind of wake up to a provision all of a sudden and raise an issue again that I feel is often has been debated for quite a while. But that's a common thing in these types of deliberations. I don't want to take more time here. Don, I think you want to.
Yeah, thank you. Thank you, Stefan. I just wanted to maybe just put an issue on the table that people need to think about, which is whether we're undoing some of the things that the 1997 model law intended to be done, because it's essentially a law about deference to foreign law, right? Comedy. And whether under the guise of choice of law now, some of those things are being undone, and whether we're conscious of what we're doing in terms of undoing the model law. So that's really the question I have, and whether anyone's thought about that.
That is the most important consideration I think that we have going into this. And one thing for sure, when we go to amend the guide, is that we're not going to upset the model law. And I would think Judge Cropper and Stefan and everybody, I think that is a very important consideration. And with this choice of law, I call it controversy and deadlock. Other people call it negotiating and deliberations. I think that's a really important concept there. I bring up oftentimes, okay, well, what if I sell widgets and I have inventory that goes all over the world? Are we going to have, we're going to have 3 months down the line try to figure out which insolvency law applies to all the different widgets wherever they are at the time of that the bankruptcy was filed, right? That seems very contrary to what the model law intended with deference to the foreign main proceeding. And I think that comes up over and over and over again with these deliberations, and it's kind of a tangential thing with the choice of law, but with the guide it's going to be forefront and center, right? Like, what is the model law intended to do, and which we will have to defer to Judge Gropper and people who were there, when they were coming up with the model law in the first place. But I think that's extremely important.
Yeah, just to add, Adam, go ahead.
No, go ahead, please, Stefan.
Just one quick addition there is actually if it was to become a new model law that includes provision on applicable law, we are on our way maybe to actually add a means of support that would actually defer to a foreign law. So you could ask a court for support in a way that actually allows you to use a tool under the foreign lex concursus in your jurisdiction, which I think is the most obvious way to say, please defer to this day as it is provided in the foreign law. So I think that is something that could even add to the basic ideas of the model law of 1997 and make it more efficient.
I was going to mention that we in the United States delegation would be very happy to simply stay with the current version of the Guide to Enactment, which basically has a law of the bankruptcy, the lex fori concursus, as the applicable law to almost all matters except some financial contracts and labor agreements, which is also built into the new rules. That is not acceptable worldwide. It's certainly not acceptable to the US, to the EU, and that's simply a fact of life. I would also just like to comment on Stefan mentioned that some seem to be wavering from a commitment to produce these rules as statutory amendments. That also is a deference to EU and civil law jurisdictions. We never, or almost never, make choice of law provisions into statutes. And I don't know that that's something that's done in any common law jurisdiction. But can we live with this in the form of a statute? Sure. Is there any chance that we will adopt it as a statute? None whatsoever. I'm not sure we would adopt any statute of any kind relating to insolvency. We've had no success in attempting to get a very few, very modest corrections to the original model law into our Chapter 15 with so far, after 4 or 5 years of effort, no success at all with Congress, and things are not getting better as far as I know. But can we live with a statute? Sure. If the EU is committed to it and voted in this fashion, and the number of civil law jurisdictions in the room are far exceed the number of common law jurisdictions, and it can certainly we can certainly live with that, and I don't think we're trying to go back on it when we say that it's unlikely to be adopted. It doesn't mean it won't have any effect. Our choice of law provisions are included in the restatement, among other sources. Actually, years ago, III collaborated with the American Law Institute on a set of choice of law principles that were drafted by Ian Fletcher, a common law professor, and Bob Wessel, a civil law professor. They are, in many respects, excellent. They need to be brought up to date, and I think that's something that we should think about for the long-term future, because that would actually make these principles spot on relevant to common law jurisdictions. But they'll be relevant. They could be made relevant anyway.
Well, you bring up what I was highlighting just as like a observation this go around was the civil law jurisdictions really want hard and fast rules. And it was brought up multiple times. What happens if you have not for for developing countries, like if you have unsophisticated judges, you need to have it's black and white. Here's what happens under these circumstances. Whereas I think in the common law jurisdictions, we want more flexibility, and especially with our case law with Chapter 15, flexibility is great and it makes things work really well. And so that is just an overarching kind of going back and forth. Do you want a model law? The United Kingdom, they had a really good point. They're like, well, if you make it a model law, as opposed to like a guide or a toolkit like we did for asset tracing, and you don't adopt it, well, then does that mean if you bring it up in court that the judge says, well, we didn't adopt this, so none of this applies, and we're going to do the opposite? But for the civil law jurisdictions, they want the law and they want it to hopefully get enacted, and so they have rules to go by. And so that's just kind of like currents that go on in the room as to when you're debating really anything, and it is quite interesting.
Well, we lost that battle.
Yeah, we did.
That one said that, and you win some and you lose some, but no one is forced to adopt this as a law or in any other fashion. Frankly, I'm not sure that any member of the EU is actually going to ever adopt any of these provisions, but I'm hopeful, and again, Stefan may wish to speak to this, that it may have an effect on a revision to the EU insolvency regulation going forward. The provisions of the EU reg relating to secured debt, for example, I think everyone agrees that they don't work because they only apply where the property has moved. Is that right? And that doesn't make any. I mean, I'm speaking out of turn, but that doesn't make any sense. So maybe they'll have a life of their own. We're also stuck, I think, with these Latin terms. And somebody who hadn't been at prior meetings said today, why are we using Latin terms? That's crazy. We have Chinese in the room. We have Malaysians in the room. What do they know from Latin? And indeed, what do we know from Latin? But Adam, I'm afraid that train also left the station. The room last time in I think it was in New York or no, it was in New York last April. Agreed, or didn't agree, but the overwhelming majority was to use the Latin terms that we've been using.
Everyone tried desperately
And the Chinese,
to not use the Latin term.
the
Everyone
Chinese
tried
didn't speak up.
Yeah.
It
No.
is about Roman law, not Latin terms.
Well,
Yeah, no one wanted to use Latin, but no one could figure out a better way to pursue
no
it
one.
than to use
Oh,
it.
yes. A lot of Europeans love Latin.
I love Latin.
Yeah, it confuses things wonderfully.
Yeah.
I've been translating from Latin into Italian and vice versa for 8 years at school. So I must say that
Well,
I must love Latin.
I confess I'm old enough that I took Latin too once upon a time and have regretted it for the last 70 years, 60 years.
Hey, Andre, you've got your hand raised, I see. Would you like to say something? Once again, I want to say Andre has provided very valuable research that has really helped the delegation, and I've been spreading it around to show people what has happened with choice of law and secure transactions over the last 30 years in different countries, and has actually been pretty helpful, I think. Andre, go ahead. You're on mute, though.
You have to unmute.
You're on mute, Andre.
That better. Thanks, Adam. Just a few words. Unfortunately, I couldn't attend, but I think if we look holistically from what I gather, of course, this is a huge long-term evolutionary process of cross-border insolvency, but I think the pertinent issue now is actually, well, if you want to see it that way, are we taking the model law to the next level with these new proposals, etc.? Well, if they are adopted in the end. But it seems to me that we may end up, in theory, we may end up in a situation as is that there are still many states who don't have a formal statutory regime for cross-border insolvency. We have the number of states, about 60, that have adopted basically the 1997 version of the UNCITRAL model law. And here comes, well, of course, there are new things happening all the time. The insolvency-related judgments and all these things are developing. And this is, as far as I'm concerned, just the normal law development that's taking place. We can't remain stuck with the 1997 version all the time. But my question is really, should we move into a position where some states, they decide to stick to the more procedural-based template that we have right now, and others decide, well, we will go on and we will include some substantive rules or law of choice rules in our version. We will adopt whatever comes from UNCITRAL at a later time. I think my sense is basically, and from what I heard from Judge Gropper, is basically that even if we have these two dispensations, we will still be in a better position if some states adopt the newer rules, etc., and we have people or states that decide to remain with the 1997 template. It seems to me there will still be synergy and communication between these two versions. And from what Judge Gropper said, it seems to me that it will still be possible to sort this out with the choice of law rules applicable in the various states. If we take, and sorry for using the Latin, but I also had to do Latin, the lex concursus, which is a fairly strong entrenched principle in this cross-border insolvency regime. So that is just the one point I want to make. It seems to me it will be compatible in one way or another, especially with the common law who have more flexibility in their systems. And then, of course, the other thing is actually, I think for me, the interesting thing will actually be to serve third countries outside the domain of the EU. But I mean, that is a topic in itself. Thank you.
I'll give you, from a practitioner standpoint, here's what I hope. In the United States, we have 1521A7, which says you are not allowed to bring a U.S. avoidance action in a Chapter 15. But you can bring one from a foreign country. And in the U.S., judges will do a choice of law analysis on fraudulent transfers. So if I represent a foreign representative and I come to the United States, there's a choice of law analysis done. It says, oh, it should be a U.S. avoidance action. Well, I can't bring that into Chapter 15, so now I have to go file a 7 or 11, which is exactly what Chapter 15 was supposed to prevent me from having to do. So I hope if we have choice of law provisions on fraudulent transfers, that it should be the lex fori concursus. Even if the U.S. doesn't adopt the model law on choice of law, I can bring that to the judge and say, hey, look, you really should apply the lex fori concursus despite your choice of law analysis. Can you please give me that deference? That's just one example of what I hope we can achieve with this. From my perspective, Judge, what do you guys think? Fetty, I see you're raising your hand. Go ahead.
Frederick did. Well, I think that it would be hard for a judge to ignore a specific provision of the code with regard to not using U.S. avoidance provisions in a Chapter 15. But that doesn't prevent use of those provisions, because it's easy for a foreign representative to file a case, or to try to file an involuntary case. I had a case in which a liquidator from Bahrain, which had no avoidance law at all, wished to use U.S. avoidance law to avoid a transfer or a set-off that had taken place in the U.S. And therefore, it was perfectly appropriate, I thought, or that wasn't argued, to apply U.S. law. And they did. They filed an 11. They brought the avoidance proceeding. They got a decision which refused to dismiss it, and they settled it, and then they dropped the 11, went back to proceeding on a 15 basis. So, I mean, it has been done, and I think it's been done successfully. Why is that provision in the model law? It's in there, I believe, and Don, maybe you can speak to this, because Professor Westbrook, who was a member of the U.S. delegation, was of the view that if you're going to use avoidance proceedings, you shouldn't use them in an ancillary case like a 15. You should have a plenary proceeding where they are part of the overall legal framework. And that's the reason for that exception that we introduced into the model law.
Yeah, I think that's right, Alan. I remember we had all just gone through the Maxwell experience where you had 2 plenary proceedings.
Yes.
So you had the option under either law, and it gave the judges the opportunity to select which one.
On this point, I would commend to everyone a decision from Chief Judge Glenn about 4 years ago in a Chapter 15 case out of Norway called Norske Skog Industria, where he goes very carefully over the New York and federal choice of law principles that would apply here. And if anyone wants to delve into it a bit further, there actually is a contrary decision regarding choice of law coming out of the Abu Dhabi ADGM court a year or so ago in the NMC healthcare case. Felicity, I got into a very spirited debate with one of your chamber's mates over precisely that issue at a forum last May. But the different approaches, including the approach of the ADGM court in applying a law that did not even exist at the time of the transfer that was challenged, is quite novel.
Yeah, I opened up a fun issue here. It goes back and forth, and especially with the U.S. now, there's cases where even if they pick the choice of law from a different jurisdiction, they're applying U.S. statutory defenses to it. And so this is just one of the cans you can open up when you go into choice of law and the things that are getting debated in Working Group 5. It's quite interesting.
I just wanted to add 2 comments from a European standpoint. One is just to allow you to understand, not just for UNCITRAL purposes, but in general, the complexity of the issues at stake when we are talking about harmonizing the European framework. More than 25 years ago, my experimental degree thesis was a comparison between UNITRAL principles, Code Lando, and Codice dei Privatisti Europei that the European Commission was considering for a European commercial code. And the project is still up in the air. And the reason, what I've been told, the most difficult obstacle to overcome is around secure debt. So securities, guarantees, and I entirely understand it because looking at the problem from a lender or investor standpoint, you need to have certainty around where you're going to enforce and how long does it take and whether there is a stay or not and what is the avoidance action. Because if you don't have it, it changes entirely the value and ultimately the borrowing base on the possibility to lend money or to make the investment or not. And I think that this is the answer to be given, because I think everything could work if it gives predictability. But with forum shopping and lex fori concursus, there's not much predictability. And I do not have the answer. But every time I listen to the conversation, and when I was in Vienna as well, I was like, that is a nightmare for any lender. Like, this is exactly the situation where you don't want to lend money. Like, it's I'm not lending here. Because you need to know exactly where you are going to enforce. Otherwise, you cannot make a net orderly liquidation value assessment, and otherwise you cannot create a borrowing base, and without a borrowing base, you're not lending any money. So I hope that no lenders would ever listen to these conversations because they would be paralyzed. But the good news is that once there is an answer to this need, then there is probably the best solution we can get to.
Yeah, well, once again, it goes back to, like, in the U.S., for example, you're operating under state law for your attachment and perfection, and that's what lenders and borrowers are kind of going under. Then all of a sudden, boom, there's a bankruptcy, and this federal law applies, right? And so the EU, it's not like it's different. You're operating with the states and how they work, and there's automatic assumptions and everything, and there's a different fundamental base understanding of where you're coming from, which comes out in these working group 5 discussions and the informal things, and you have to kind of figure out where people are starting from. Another good example is when Mexico got up, we were talking about litigation and arbitration and a stay. The Mexican knows, well, in Mexico, the stay does not apply to litigation, so we think there should be no stay to litigation in different places. Well, I don't necessarily think that's a good overall idea macro-wise. And that comes out in the discussions, and everyone's initial reaction is, what do I do in my country? That's what everyone should do. And you have to work all of that out. But hey, guys, I think this discussion has been awesome and really fruitful. And I would really encourage, we have these monthly calls for Working Group 5, and I would really love everybody to participate. And I think would really help to have different perspectives on these calls, especially if we have members of the EU coming, and we can all talk about maybe ways we can get this deadlock through a choice of law and secure transactions and kind of get somewhere. I think it'd be really helpful. And so I would love all of our monthly calls to be this enthusiastic and this much of debate. Like it would be awesome. And I would like other perspectives too. Like Andre, with his research and our talks, has come up with some really interesting facts as to historically how these issues are handled, and other people may just know off the top of their head or have the ability to go find, like, in Asian law or in European law, 30 years ago this came up as to how you treat choice of law with secure transactions, and here's what they did. All that would be very persuasive to the people in the room.
Thank you, Adam. I think it's time to wrap up, right? So, Mark, Adam, thank you very much for introducing. Thank you very much for moderating. I can only agree that, we need this forum to exchange ideas. So the Friday calls of the UNCITRAL Working Group 5 group is important. So please get yourself on the email list. I think there's an email list, so you will get email invitations to join that call. I think it's a Friday it's the first Friday in a month.
I'm not sure. CC, do you know? Are you there?
I think it's at least Friday afternoon in Europe.
Yeah.
It's Friday morning in the US. And if you are interested in joining our future calls, please just shoot me an email and I will make sure that you are added to the calendar invites going forward.
Oh, hey, Stefan, can I make one more? There's Mark and Deborah. There's a working group 1. It's kind of been dormant for a while, and they made an announcement that it's now going to encompass cryptocurrencies, crypto exchanges, and so some of our members may want to get involved with that. There's going to be a colloquium in New York in February, and so I just kind of wanted to put that on people's radars. If that's an area where you're interested in and active, we may want to have some involvement in that.
It's very good. Yeah. These working groups are restructured, in the process of restructuring. So yeah, this is very important information. So maybe we can, or you can circulate that as well, and we circulate it amongst our members, interested members. And if enough interest is collected, maybe we have a preparatory call sometime early February probably would be the best. Thank you very much. This brings us to the upcoming call. The next virtual members meeting will be in March with a topic still to be determined. It will probably be something like that, a forum to exchange ideas, views, recent experiences, and maybe new ideas. I hope you spare 45 to 50, maybe 55 minutes of your day to join us in this virtual meeting. Then again, of course, we have 2 regionals coming up. We have the UCC Regional Conference, which will be in Miami, January 2021, in Mark's offices. Please register if you're interested and near, or not as near, but willing to travel to Miami in January. I couldn't imagine why you wouldn't. The second option is a regional for EMEA, Europe, Middle East, and Africa, which will be in Madrid on February 19. So it will be an afternoon session in beautiful Madrid in February. So again, no reason not to show up. If you need more information, please visit our website, check your inbox. We will have emails coming through, and please register. This is all I have to say for now. I wish you all happy holidays, happy new year, and I hope to see you all healthy and back again in 2026. Bye, everyone.
Thank you all.
Happy holidays.
Great discussion.
Okay.